I'm Marshall on behalf of the people.
Good morning, Your Honor. Jacob Sartz, the Fourth Assistant Public Defender here on behalf of Mr. Waltz. I request permission for Mr. Waltz to remain seated, Your Honor, due to his pretty significant, very serious medical issues.
All right, that's granted. Sir, you are Benjamin David Waltz?
Yes, sir.
All right. This is the time set for a preliminary examination today. Mr. Marshall, how we proceed?
Your Honor, the defendant in this matter is going to plead guilty to an added count 2 brandishing. And I have the MCL and penalty when you're ready.
Brandishing. MCL.
It is 750.234E.
And that's a 90-day?
Correct, and or $100.
Is that a correct statement, Mr. Sartz? There's an added count 2 of brandishing of a weapon under 750.42341E. It's a 90-day and or $100.
Correct, Your Honor.
All right. May I inquire of your client of his advice of rights
Yes, sir.
that you've tendered to the court?
Yes, Your Honor. Thank you.
Mr. Waltz, you've signed an advice of rights indicating that you're aware of your trial rights in this matter. There's 12 on this sheet, and Mr. Sartz has gone over them with you, and you've signed them to that effect. Is that correct?
Yes, sir.
All right. I'm just going to go over 3 main ones, and then we'll continue with the plea. You understand that this is a 90-day misdemeanor and or $100, which are the ultimate penalties the court could sentence you to pursuant to brandishing of the weapon. It's an added count 2. You have the right to trial by jury. Do you understand that? You have the right to be presumed innocent, and you have the right to have Mr. Sartz represent you in court and contest any charges or cross-examine any witnesses brought to trial against you. Okay?
Yes.
Oh, right. And you have the right to silence you have the right to silence, and you cannot have that silence used against you in trial. Do you understand that?
Yes, sir.
All right. Raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to July 21st of 2023 at the offense location of Ballard Street in the city of Lansing, Ingham County. Were you at the Ballard Street address in the city of Lansing, Ingham County on that date, July 21st, 2023?
Yes, sir.
Okay. And at that time, in count 2, did you have a weapon?
I had an airsoft pistol, yes.
All right. And tell me about that.
It's a spring-loaded airsoft pistol. Takes plastic, BBs, whatever. I was sitting on my front porch, shooting at a cardboard box in our front lawn. And
at some point in time, were you waving that pistol around?
no,
Mr. Sartz.
Sure.
Yeah, Your Honor.
Right.
Mr. Sartz.
Yeah. All right, we got to do the factual
Yeah,
basis
to-
of felonious
yes,
assault in order to
yes.
get. I'm aware of that, Bob. Thank you.
All right. So you'll do the factual basis as to count 1, which is, so did at some point in time, did you point the airsoft pistol at somebody?
no, but I did hold it up in view for some.
Your Honor, may I have a brief moment?
Sure, Mr. Sartz.
I didn't even. Yes.
My apologies, Your Honor.
No worries. Did you want to continue on with the plea or?
Yes, Your Honor.
All right. Mr. Waltz, at some point in time, did you point the airsoft gun at Miss Wood?
I made a comment as to having a gun and showed it to her.
And you showed her the gun?
Yes.
Okay. And I think what comment did you make?
It was, what kind of moron would be talking shit to somebody who's holding a gun?
Who's holding a gun? Okay.
Yes.
I find that as count 1 felonious assault, an adequate factual basis. So I can take that in place of the brandishing of a weapon to count 2. Any questions concerning that, Mr. Marshall?
No, Your Honor.
Mr. Sartz.
Thank you, Your Honor. And just briefly, Mr. Waltz, you can understand why your neighbor would be concerned
No.
about you displaying something and then you informing your neighbor that it appears to be a gun.
Absolutely.
And you can understand why she might be in fear that it might be a real gun, or that you might be able to potentially use it and shoot her in some way, correct?
Absolutely.
All right, thank you.
Thank you. And your admission today is it was an airsoft gun that you pointed.
Yes, sir.
All right. I find that factual basis to be knowing, voluntarily, and accurately made. I would take it as to count 2, brandishing of a weapon, the 90-day misdemeanor. So I'm going to refer to probation at this point. And what they'll do is they'll prepare a report for me. And then at sentencing, on the date of sentencing, we'll go over and see what options we have available to us, okay? I'll have a sentencing date. So the probation's on the 5th floor. Make sure you stop by them on the way down and set up a meeting to answer any questions they have for the report they're going to prepare, okay?
Okay.
Sentencing date of
October 6th at 8:30.
October 6th at 8:30. And you'll get a notice to that effect on the October 6th at 8:30. That's the date of sentencing on this matter. All right, sir?
Yes, sir.
Anything else for the record in docket 23-02246, Mr. Marshall?
No, Your Honor.
Mr. Sarts?
Thank you, Your Honor. May I just be heard about the no contact order?
Absolutely.
Thank you. Your Honor, the backstory here is that this was basically a dispute between a couple of neighbors. It escalated. Mr. Waltz has pled guilty this morning to a brandishing charge, which is a 90-day misdemeanor with a $100 fine. Respectfully, Your Honor, Mr. Waltz has a urgent situation that relates to the no contact order. He requests permission at this point to return back to his home. He just lost his temporary housing early this morning, Your Honor. He is currently homeless. He has a series of very serious medical issues, including really bad injuries to his ankle. He needs at this point to be able to get back home and convalesce. His mother also is elderly, so he provides care for his mother. Now, important things to note here, Your Honor, this case has been reduced now to a brandishing, which is only a 90-day misdemeanor, $100 fine potentially. From what the police report reads, the complaining witness here was in the process of moving out anyway. To the best of our knowledge, that process is nearly complete, or the neighbor has largely moved her possessions out. There is enough distance there where Mr. Waltz can stay safely in his home without directly being right next to, or they're neighbors, but there's enough privacy and there's enough distance between the two houses that Mr. Waltz could live in the house without directly interacting with the complaining witness outside of perhaps something incidental. There's been no allegations of any violations of no contact order. Mr. Waltz, Your Honor, has already served 12 days in jail on this already. So before he was able to get out on bond, served about 12 days, correct?
Well, that's technically an unrelated charge. It was for child support.
Okay, but still, you're in custody for 12 days.
Yes.
So, Your Honor, under the circumstances, due to his particular medical issues and the nature of these circumstances, I would request an amendment to the no contact order, perhaps a reduction in the range. And certainly if the complaining witness has any disagreements with it or any concerns, we can address it at sentencing. But there's been no issues so far. And to the best of our knowledge, the complaining witness is moving out, Your Honor.
All right, thank you. Mr. Marshall, any comment on the modification of the no contact order?
Your Honor, I did have contact with the victim. She did tell me she was moving out of the home. I didn't get an exact date. I would leave this to the discretion of the court, given the plea to a misdemeanor.
Thank you. I'm going to grant the request for modification of the court order. I'm going to continue with the no contact order to Esther Wooden. This appears to be some neighborhood dispute on some level, or the like behind. So continue no contact with Miss Wooden. What's going to happen is if you have any contact with Miss Wooden, she's going to end up reporting it to the police, and then they're going to come and they're going to indicate you violated the no contact order. What I'm doing is modifying it so you can go home. Okay. So I've taken away the 2,000 feet. All right. So you can go home. You can start whatever convalescence is necessary and make sure, but you're to continue to have no contact with Miss Wooden. That may not be an issue because she'd be moved out, but regardless, and no contact is direct or indirect. So you can't tell somebody to contact her or come to contact with her, or have a neighbor contact her, direct or indirect. But with that understanding, and you've pled to a misdemeanor today, I will modify that I'm just going to take out the 2,000 feet. Just continued no contact with Esperwood. Okay.
Understood.
All right. Anything else for the record in 23-02246, Mr. Marshall?
No, Your Honor.
Mr. Sarks.
Nothing further, Your Honor.
All right. Thank you. You're all set. We will see you, sir, on October 6th.
Thank
Okay.
you, sir.